When you're forming up a trial story, you got to remember that the story has a three-act structure. It has a beginning, it has a middle, and it has an end. And you think of your trial story. What is the trial story I'm trying to convey to the jury? And what is the beginning of my trial story? The middle of your trial story is going to be the evidence, the hard evidence that supports the beginning. And then what is the end of my trial story? The beginning is going to be the information they need to form their opinion, to form their model of what the case is about, consistent with yours. The middle of your trial story is going to be, now that they've got that trial story formed in their mind, they're going to be thinking in terms of looking for evidence that supports their trial story. It's like an Agatha Christie story, where everybody in the beginning likes to figure out who done it. Well, early in the game, you think you know who did it. Whether you realize it or not, you start looking for clues that support your idea of who did it. The middle of your presentation should be hard evidence. This is where you show the x-rays. This is where you bring in the hard numbers. This is where you bring in the evidence from the expert witnesses to firm up what you led them to believe in the beginning. And then the end is where you close your trial story with, this is what happened, here's the documentation, here's the evidence of what happened, here's the end result of what happened. This is where you get to your damages. So that is a basic three-act structure of a trial story. When you're forming a trial story, this is what we do. You take each participant, everybody in the case, you write their name down, and you tell the story from their viewpoint. You try to think, okay, in the first person, you take the person standing on the corner who saw the accident and say, okay, now as a first person, I'm going to tell the story. I'm going to write down the story of what this person knows and what this person will be able to say. Because if you tell that story in the first person, just the fact that you're doing it in the first person, you're putting yourself in the position of that witness. You will make discoveries about that, what that witness could see, couldn't see, what that witness's viewpoint is. You'll make discoveries about it that you could never make if you're looking at it just reading their statement. So when you're putting together a story, you look at every viewpoint. You take every participant, every witness, then you look at it from the viewpoint of a narrator, the helicopter view they call it, as if you're looking down on the scene and telling the story from that viewpoint. So getting all your viewpoints together gives you the elements of what your trial story is about. There's a very important maxim of social psychology. It started years ago with a fellow named Fritz Heider. And what he said was, in 1958, in the psychology of interpersonal relationships, Fritz Heider made a very profound statement that is extremely important to us today as trial lawyers, and we need to look at this in every single case that we consider. He said, behavior engulfs the field. What does that mean, and what does it mean to us as trial lawyers? Behavior engulfs the field. What he's talking about, the fields of observation. When people observe, they observe behavior. The fields of perception, their perceptions are grounded in the behavior. And the reconstructive memory, when they're recalling it later to testify about at trial or to retell the story, behavior prevails in reconstructive memory. So fields of observation, perceptions, and reconstructive memory, behavior engulfs the field. What does that have to do with us? It has everything to do with us, because what that says is that people and personalities are in the foreground. They're in the foreground of observation, they're in the foreground of perception, and then they're in the foreground of recall. People and personalities are in the foreground, and situations and circumstances are in the background. If you have a situation where you have a person in an event, you have circumstances surrounding that event, You have a situation occur when people observe it. What they observe is more of the person than observing the circumstances surrounding the event. It's more about the person than it is about the situation that occurs. People are extremely important, and then when they recall it, they recall more about the people, and their recall about people can shade their recall and their retelling of the story about the circumstances and what happened in the situation. This becomes extremely important to us. Jurors attribute causation factors to either A, the personality of the parties, and B, the situations and circumstances surrounding the events. A very good friend of the trial bar, he didn't mean it to be this way, but he is a very good friend of the trial bar. He didn't write this for the trial bar. Is a brilliant PhD from Stanford named Lee Ross. And in 1977, Lee came up with what is known as the fundamental attribution error. And what he learned in that fundamental attribution error is that observers attribute causation primarily to personalities and secondarily to situations. So if you've got a situation that's very advantageous to the plaintiff's proof, but you've got a plaintiff with a personality that makes the jury believe that just looking at it, that, well, they probably did this, the personality is going to overcome the circumstance. That's the fundamental attribution error. They're going to look more at the personality. Anti-plaintiff bias. There is unquestionably an anti-plaintiff bias today. So the anti-plaintiff bias makes this a disadvantage to plaintiffs, which we have to address. Plaintiffs do not go in to a level playing field at the courthouse today. You go in with anti-plaintiff bias, particularly in personal injury cases. We go in on the downside of the fundamental attribution error. What we have to do is we have to look at in each case, we have to look at the personality versus the situation. We have to look at internal forces versus external forces, which I'll explain. And the attribution to personality is internal causation. In other words, they look at a personality and they think the jurors overestimate the influence of the parties' perceived internal attitudes, their personality traits, their characteristics, as they influence causation and damages issues. So if you have a plaintiff that's had a course of conduct that is adverse, then the jurors will apply the fundamental attribution error. You'll give them something to work with, and they'll overestimate the influence of the plaintiff's internal attitudes, the plaintiff's personality, the plaintiff's characteristics as being causative on causation and damages.